Next case on the docket is Bollinger versus State.
Good morning. May it please the court. My name is Thomas E. Cushman of St. Augustine. I represent Timothy Bollinger in this case. I would like to reserve about 5 minutes for rebuttal to the state's case. And I'd begin, there are 2 issues in this case. One is the insufficiency of the evidence of impairment and bad driving. Tim Bollinger was driving north on A1A with his girlfriend. The evidence indicated he was driving within the speed limit. He happened to come on Panama Hattie's bar at the time they were closing. There was a large crowd of people crossing Highway A1A. Bollinger proceeded within the speed limit. At a moment too late for Bollinger to brake, a man with a blood alcohol level of 0.27 ran in front of him. Bollinger attempted to brake, was unable to do so in time, and hit the person who subsequently died.
The evidence of whether he attempted to brake was equivocal at best. Would you agree with that?
No, sir, I would not.
Well, there were some people who said we didn't hear any squeal of brakes, and others said we thought we heard a slight one.
Well, they wouldn't have heard any squeal of brakes because there was ABS brakes. The brakes would not squeal. The Sergeant Bedoin, who turned around, he was controlling the crowd, turned around, said he heard it, and he saw the impact. Officer Hammonds was also there. He heard the braking. Now, there was another witness who said he didn't hear any braking, but yeah, so there is some equivocal question. But on the other hand, when an individual runs in front of a car moving down the road at 30 miles an hour, Sergeant Prescott, the traffic homicide investigator, said that it would take 3/4 of a second to hit the brakes anyway. And by that period, he'd have traveled, I think the calculation was 36 feet. And when someone starts in the middle of the road, which is where Grotzinger, the victim, did, and ran in front of Bollinger's car, there was no possibility that Bollinger could stop.
Well, he hit him with the front passenger side, right?
Right. And Bollinger was sprinting across, so I think that's consistent, Your Honor. He almost made it. Bollinger did everything he could do to brake, but it was impossible to happen. Now, the evidence of impairment...
He didn't attempt to swerve, according to the witnesses.
No, sir, he couldn't swerve. But like I say, that's, I think, an indication of good driving, not bad, because he was surrounded by the people from the bar on the left side and on the right side, so swerving would have been an endangerment.
Well, apparently the jury didn't believe that.
Well, I don't think he was argued very strongly, but, the question is, someone runs in front of someone, what's to do? You either brake or you swerve, and if you can't swerve, you brake, and you brake as quickly as you can. But the man had a 0.27 blood alcohol level that ran in front of him.
And your client apparently also had
0.16.
0.16.
Yes, sir. And the state argues that did impair him, but there was no field sobriety test. There was no indication at all of impairment.
Did there have to be?
Yes, sir, I think there does. There has to be something to indicate more than a blood alcohol level.
Was there any witness to testify that they smelled alcohol on him?
Sergeant Prescott said when he opened the door to the cab, he smelled alcohol. Not a strong smell, but he smelled alcohol.
Is there another witness who also said that he smelled alcohol?
No, sir. There was another witness who said he escorted Bollinger out of the car. That was contradicted by 3 other witnesses. But he said he did not smell alcohol.
But he said he was staggering and slurring, right?
He said, well, actually, he couldn't remember how many drinks he'd had. He couldn't remember whether Bollinger got out of the car or he helped him get out of the car. 3 other witnesses said that he saw
But at some
Bollinger.
point, didn't he testify that he was both staggering and slurring?
Yes, he did.
And what is the relevance of your argument which says, but there were 3 other witnesses that said something else? If you're talking about whether there was evidence or sufficient evidence to go to the jury, it doesn't matter if 3 witnesses said something different, does it? As long as there was a witness who gave evidence which, if believed by the jury,
Well,
would
there's
show
2 significant
impairment?
things. One is that that was the first time, the man's name was Benjamin Bruner. It was the first time Bruner had ever said he'd done that. That was contradicted and cross-examined.
What's the relevance of that? The jury could still believe it, correct?
The jury could still.
So you can't argue to us that we shouldn't believe it because it was inconsistent with what he'd said earlier, right?
Right. But the point being that the evidence was very thin on the impairment. Now, combine that with the improper comments on Bollinger's silence, and when we start examining...
There was one comment.
Sir?
There was one comment on silence. And that was a response from a police officer to a question, right?
Actually, there was 2 comments, the way I interpret it. The other one was made by the prosecutor in asking the question of Officer Hammond. That was one witness. The very next witness was Sergeant Prescott, who said he opened the door, smelled the alcohol, asked Bollinger whether or not, if he wanted to make a statement, and that's when
the objection came.
And that the second objection, and the court, of course, ruled that that was a comment on the silence.
Gave counsel the choice of either giving a curative instruction or not.
Right.
Gave the curative instruction.
Gave the curative instruction.
Under advisement whether to grant a mistrial.
Right. And she should have granted the mistrial at that point, because that puts us in the context of harmless error. And the DiGiulio case makes it pretty clear that this is a high-risk error. The motion for a mistrial should have been granted because now the state is in the position of having to prove beyond a reasonable doubt that the successive comments on Bollinger's right to remain silent did not contribute to the verdict. And when you combine that with the very thin evidence of impairment, we don't have a case where the evidence, as many cases say, well, the evidence was overwhelming, therefore it's harmless error. In this case, the evidence was far from overwhelming.
You're confusing me a little, Mr. Cushman, because you're talking about the thin evidence of impairment. I mean, there was a blood test that showed that he had twice the legal limit of alcohol in him, right?
Yes, sir.
So the evidence of impairment was actually pretty strong. What you're talking about is whether or not there was sufficient evidence to take him off and get the blood draw.
Well, that's true. I am arguing that. But on the other hand, I do not concede that a 0.16 blood alcohol level is equivalent to impairment.
It doesn't have to be.
Well, I respectfully disagree. I think there has to be some evidence of impairment, not just a blood alcohol level.
For purposes of drawing the test, it just has to be under the influence.
Yes, sir. No, I'm talking about
Different.
Yeah, right. That is different. But still, impairment is the issue. There was no bad driving, and that's the tragedy here.
What's the statute say?
I don't have it in front of me, Your Honor.
See if I can find it.
I think Ms. Parrish quoted it in her brief.
Ms. Parrish, you know the statute number that he was convicted under?
316.193.
316193. This just says any person who is in violation of subsection 1, which of course is the amount, who by reason of such operation causes or contributes to causing.
Yes, sir.
The death of any human being.
And that, I think, involves evidence of impairment. I mean, I kept looking at DUI, but there has to be some causation, not just the blood alcohol.
Or contributes to causation.
Well, there has to be some evidence of that.
Well, there was some evidence that he never hit the brakes, and there was some evidence that he never swerved. So I guess I'm having a hard time understanding.
Well, again, failure to swerve, I think, is evidence of good driving, not bad.
Might have been, but the jury didn't buy that.
Well, but you combine that with the requirement of the harmless error rule that the state has to prove beyond a reasonable doubt that the comment did not contribute to the verdict. And we suggest that it's clear that it did, because there's not a question about whether or not this was a comment. The court ruled it was a comment. The state conceded it was a comment. And therefore, without proof that it didn't contribute, and there is none.
What's the effect of the instruction from the court on the error?
I'm not sure I understand the question, sir.
The court gave a curative instruction immediately after the error, gave defense counsel an opportunity to either have an instruction given or not.
Well, since it's successive to instruction in the previous witness, frankly, I think it just contributes to the pointing out the highlighting of the comment.
That's why Judge Berger asked, do you want to give it or don't want to give it? And the selection was, I want to give it. What are we to make of that?
That because of that the court was trying to prevent error, but what the court should have done, what Judge Berger should have done, simply grant the mistrial and start over. And therefore, I think the verdict should be reversed. Thank you.
You've got about 4 minutes for rebuttal.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. It's the state's position that the trial judge properly denied the motion for judgment of acquittal. If this court has no questions about that.
I want you to comment on whether a mistrial should have been granted after the second comment, after the witness said he didn't say anything.
Okay, that would actually be the first comment, because there was no answer to the first question that was asked. And no motion for mistrial was made as to that first question. I think that the curative instruction dissipated any error which may have occurred. I mean, the state...
How do we measure that, Ms. Parrish?
Beyond a reasonable doubt, you have to look at the evidence. And according to DiGiulio, you have to look to see if the state presented conclusive evidence. And I would submit in this case that they did. Mr. Bollinger was driving the vehicle. He had a blood alcohol level of 0.165, 0.166. He hit the victim and killed the victim. My review of the record, I don't see how that one isolated comment vitiated this entire trial. The judge gave the curative instruction. There's nothing from the record to indicate that the jury didn't follow that instruction. In the instructions given to the jury prior to their deliberations, they were again instructed that, the defendant didn't have to take the stand. You can't interpret his silence as to mean anything. The jury found this defendant guilty because of the evidence, not because of this comment.
My concern is how isolated the comment was, since immediately preceding it, the prosecutor tried to explicitly get it into evidence, and it was ruled in. This isn't the typical case where you ask some open-ended question, and out of the blue, the witness comes up with something totally unrelated to anything you expected him to say, or that was before the court. It appears that the prosecutor was trying to get this information before the jury, because he tried with the previous witness, and when it didn't work, he asked the second witness a question that would allow him to give that answer.
I would disagree with that. I will admit that the first question was not a good question to ask, but there was no answer given, and that question is equally susceptible to being interpreted that the defendant did give some kind of statement. The jury doesn't know. It could have given a statement, could not have given a statement. The jury was instructed not, I realize that, but the jury was instructed to disregard that. Once again, there's nothing in the record to indicate that they didn't follow that instruction for the first question. When Officer Prescott testified, he was asked, what, if anything, did you notice when you made contact with him? you know, he was looking for the last sentence, that he smelled alcohol on him, not that I put him in the car, asked him to tell me if he'd like to tell me what happened, and there was no response. That question cannot be interpreted as trying to get that kind of answer. I would disagree with that.
And what did Judge Berger rule with respect to whether it was an intentional?
She ruled that it was not, that it was an unresponsive answer. So I would submit that clearly that error was harmless in this case, and that Judge Berger did not abuse her discretion in denying the motion for mistrial. If there are no other questions, I would ask that you affirm the conviction, and I'll rely on my brief.
Thank you, counsel.
May it please the court, when we're talking about harmless error,
Counsel, before you talk about harmless error, does it make a difference whether the comment is intentional or unintentional?
I don't think it makes any difference at all, Your Honor. I think it makes, it's not a question of did the prosecution play unfairly, and I didn't suggest they did. The answer was not responsive to what was asked. On the other hand, the comment was made, and this is not a baseball game where you're playing fair. It's a question of whether or not the defendant gets a fair trial. And because of Sergeant Prescott's comments, he did not. And
Now,
we're suggesting that...
Did the defendant take the stand in this case?
Sir?
Did the defendant take the stand in
No,
this
sir.
case? Did not.
And so what we're saying is, in the harmless error analysis, you take into consideration whether or not the evidence is very strong on the prosecution, or in this case, I would suggest underwhelming. There's very little evidence of impairment, very little evidence of bad driving. And taking that in consideration with the two comments, one's questionable whether or not it could be considered a comment, but the issue was brought up. The jury was instructed on it. Then the next witness up is Sergeant Prescott with 21 years experience, who did a very minimal job in doing the investigation. He'd done 3 in 18 years involving alcohol. But then Prescott gets on the stand and mentions the fact that Bollinger did not want to make statements. And so here we have it brought to the jury's attention again. And that puts the state in the position of having to prove beyond a reasonable doubt that the comment did not contribute to the verdict, or stated another way, as it says in Chapman versus California, that there is no reasonable possibility that the error contributed to the conviction. The state has not proven that. They can't prove it because clearly it did. It was a coin toss otherwise. With the comments on silence, the jury doesn't know. And so they have very little evidence to consider, and they convicted him. We suggest that the conviction was wrong. It was a result of an unfair trial. We ask this court to reverse Bollinger's convictions, remand it back for a new trial. That's the proper thing to do. We suggest that that's justice in this case. Thank you.
Thank you, counsel.